Good morning. Welcome to Parul University. Welcome to the webinar series organized by Chemical Engineering Department, Parul Institute of Engineering and Technology Diploma Studies on why, when, and how to file a patent. Today we have a renowned expert, Dr. Sunita Ratan, Dean, Science, Technology, and Director, Amity Institute of Applied Science, Amity University, Uttar Pradesh, Noida, India. Ma'am is the Fellow of Royal Society of Chemistry, London. She has held many administrative and academic positions throughout her career. Ma'am has a rich experience of 25 years in the academics and research. Ma'am has published more than 60 research papers in the reputed international journals and presented around 70 papers in national and international conferences. Ma'am has also given more than 25 invited talks at various international conferences and has filed 15 patents, out of which 4 are granted and 3 are in the pipeline at the final stage of being awarded. Ma'am has edited a number of books and has contributed chapters in the books with publishers like Royal Society of Chemistry, Springer, and Nova Publisher. Ma'am has funded projects from a reputed funding organization like DRDO, DST, IUAC, BRNS, SERB, and 2 from international agencies such as Inter-Atomic Energy Association, Austria. In addition to this, Ma'am has the above assignments. She is also serving as a Secretary, Asian Polymer Association and Society for Biomaterials and Artificial Organs from Delhi. So, on behalf of our principal ma'am, Professor Ruchi Srivastava, and Parul Institute of Engineering and Technology Diploma Studies, Chemical Engineering Department, we welcome you, ma'am. Okay. Now I'll request Dr. Sunita ma'am to present the slide.
Yeah. Thank you so much, Dr. Prabha. It was a nice introduction, very elaborate. If you allow, I can share my slides.
Yes, ma'am, please. It is presenting.
My screen is
yes,
visible.
ma'am.
Yeah. The slide is visible, right?
Yes, ma'am.
Okay, so very, very good morning to all the students. 1 second, I think something has gone wrong.
Yeah.
My slides are again not there. 1 second.
Ma'am, you have to again present it.
Yeah, I will.
Yeah.
Okay. Now I think it's presented. No.
Yes, it is coming. Okay. Right.
Okay. So, very good morning to all the students. You might have been hearing about patenting, right? What is a patent, right? So, we have known that whenever we do something and we hear so much about all this, we say that why can't we patent? So, what exactly this patent is? And is it something which we cannot? Let me tell you, each and every person who can think, who has the idea, can get that patented. This is something very different. Patenting means that you get, it's a property, right? But when you go for your property, you say that property can be sold, property can be kept, but similarly, this is the intellectual wealth. Earlier, when no patents were there, we never used to think that our intellect can also be sold, can also be kept, can also pay us money. But when with this field that patent, we can talk of patenting our intellect, right? So, what exactly is patent? We say it is intellectual property rights. Property is tangible, right? I have a house, I have a shop, it's tangible, it has some money attached to it. But intellect did not have that. But with the advent of patent, intellectual property right is that yes, it is like that. So, intellectual property rights are the rights given to persons over the creation of their minds. Intellectual property is something produced using human intellect which has commercial value. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. This is intangible property which can be sold, bought, leased, or rent. It can pass under a will, can be assigned. So, the different forms of intellectual property, patent is one form of actually intellectual property right. It's not that it is the only one. When we have to get ourselves that intellectual property rights, it is patents is just one of number of properties, intellectual properties. We have patents, we have industrial designs, that is also intellectual property. We have got trademarks, trade secrets, plant varieties, integrated circuits, geographical indicators, right? So when we talk of science, this comes and this is quite obviously understood that, okay, I have a technological invention and I can patent that. But then there is another field. For example, I write a very good poem. I create a very good form of music. Is that also patentable? Yes. But the term used for that is copyright, right? So for any literary, musical, artistic drawings, photographs, performing arts, sculptures, software, we go for copyright. Now, what does that mean? Let's first discuss what do we mean by trade secret, right? Because I have already told you that you've got trade secret, trademark, industrial design, plant varieties, integrated circuits, geographical indicators. So I would like to tell you, so that I just want to help you, because you must be having it in you. You can go for patents, you can go for all these, right? But how to go, that is the crux of today's talk. So when I come to trade secret, what exactly is the trade secret? It is any practice or process of a company that is generally not known outside the company. It is my secret, the company's secret, right? For example, I give you an example of Coca-Cola. The soft drink was invented in 1856. It was never protected by a patent, only by a trademark, like Coca-Cola. It's a trademark, right? And it is also protected by industrial design. It has got a very specific design. You might have seen that it is supposed to be in a shape of women wearing a long skin tight shirt. So that is the industrial design, right? Similarly, trademark Coca-Cola. Nobody can keep this name Coca-Cola. It's only with Coca-Cola, right? And that particular type of bottle that is industrial design, that also nobody can take, right? So we can say, and then it also has a trade secret. You can see just a bottle of Coca-Cola has got trademark, industrial design, and trade secrets. You will be surprised to know that it is the composition of Coca-Cola drink is secret, and it is only and only known to two persons in the world, and those two are not allowed to travel together. So there is no chance of dying of both of them at the same time. Otherwise, the secret would be gone. So they cannot travel at the same time together, right? So that's a trade secret. So it is well kept during all these years. Nobody is able to produce a drink with exactly the same taste as the Coca-Cola is, right? So that is the top secret, right? When it comes to trademark, you might have seen McDonald's, you might have seen Google, right? They've got some trademarks. It is a sign which can distinguish the goods of one trader from those of another, like words, logos, pictures, or combination of these. A trademark as a marketing is used as a marketing tool so that the customers can recognize the product of a particular trader, right? So you can register a trademark also, right? So the mark must be distinctive, not deceptive. You cannot see, for example, we see when we go to the local markets, right? They try to mimic those, but they cannot use the same, right? So it should not be identical. It should not be similar to any earlier marks for the same. right? So that is the trademark. When it comes to copyright, it is the exclusive right given to the creator of a creative work to reproduce the work, usually for a limited time, right? Literary, artistic, educational, or musical form. Copyright is intended to protect the original expression. For example, Harry Potter, right? That's again a copyright. It is an expression of an idea. Nobody can copy it. So that is the creative work. But it is not the idea itself, but the creative work. So then there is geographical indications. That can also be copyrighted. A geographical indication is a sign used on products that have a specific geographical origin and possess qualities or a reputation that are due to that origin. An indication used to identify agriculture, natural, or manufactured goods originating from a definite territory in India. It should have a special quality or characteristics or reputation based on the climatic or production characteristics unique to the geographical location. You might have heard Darjeeling tea. So that geographical indication is there. Kanchipuram silk, Alfonso mango, Nagpur orange, Kolhapuri chappal, Bikaneri bhujia. So all those geographical indicators are attached to the. So that is again a geographical indication is also a sort of IPR, right? Industrial design, again, a design is the protection of the ornamental or aesthetic aspect of the product. For example, you have that industrial design to distinguish it from the current product, right? For example, you can see that Audi's design is again industrial design, which is registered. You cannot use the same. Mickey Mouse, no, you cannot use the same. This Mickey Mouse is the trademark or industrial design for one specific country, one specific company, right? So this is how the industrial design is there. But today's main interest or the main focus is on patent, right? The primary goal of the patent law is to encourage innovation and commercialization of technological advances. A patent is an invention which is the intellectual property of the inventor. It is the right granted by the government to an inventor. It gives the inventor the exclusive right for a limited period to stop others from making, using, or selling the inventor's product without the permission of the inventor, right? So when a patent is granted, the invention becomes the property of the inventor. As you know, that house becomes my property if I buy it. A shop becomes my property when I buy it, right? Here, I have an idea, right? I got it patented. That's my property, my intellectual property. And it really pays a lot, right? So like any property, it can be bought, it can be sold, and it can be licensed, right? So when I say that patent is an invention, what do I mean by that invention? It means a new product or process involving an inventive step and capable of industrial application. It should be new. I cannot take any, for example, I take mouse, I can take a computer, I say it's patent. No, it has to be very, very new. Never been talked of, never been published anywhere, right? And it should involve some inventive step. It should be capable of some industrial application, right? So that is a patent, right? You have, as a student, I have seen a number of BTech students, they are going for patents. For example, if you are electronics student, if you are going for electronics, if you are going for electrical, and you devise something which has not been talked about, which is not very obvious, which is very novel, you can go and file a patent. I have seen students as young as 10th class students going and filing the patents. You can also go, BTech students can go for filing a patent very easily because they keep on doing so many inventions, right? So in return for a patent right, how, if I am granted a patent right, what is my requirement? I have to disclose my invention in sufficient detail. When a patent is granted, the applicant becomes the owner of the patent. For example, I design something, I design a fan, for example, right? It is my patented product, but I have to tell it that how different it is, and how it is being made. So the one who will be manufacturing that using my patenting, using my one second. If somebody is if it becomes using my patented item, he has to pay me the royalty, right? So like any form of the property, a patent can be bought, sold, licensed, or mortgaged. Patents are territorial rights. So an Indian patent will only give the owner rights within the India, not outside. So it is inside my territory, right? So what can be patented? Now, I hope you must have learned that what is a patent, right? It requires, but then what can be patented? It's not that everything can be patented, right? What can be patented? The patent should be novel, useful, and non-obvious. Novel, not previously known or used by others. It should be useful, have a known use or produce a concrete and tangible result. Non-obvious, right? And it is, for example, it is obvious to Fosita. Fosita means person having ordinary skill in the art. If he is able to tell that what exactly it is not patented, right? So it cannot be single idea. It cannot be a law of nature. It should not be any scientific principle. Newton's law cannot patent it, right? Gravity cannot patent because that's obvious. That is already scientific principle, right? So that what can be patented? In order to be patentable, an invention must pass 4 tests. First, it must fall into one of the 5 statutory classes. Either it should be a process, or it should be a machine, or manufactures composition of matter, and new uses of any of the above. The invention must be useful, it must be novel, and it must be non-obvious. So these are the things which can be patented. Even if you have a process, for example, I, as a chemistry person, I take a catalyst which increases my rate of reaction to 10 folds. Yes, I can patent that. That's a process, different process. Machine. I make a machine which makes my work more easier, right? And it is different from the others existing machines. Yes, I can go and patent it, right? Composition of matter. I take some composition which gives me better result. Yes, I can patent that. And any new uses of the above can also be patented, but it must be useful, novel, and non-obvious, right? What cannot be patented? Mathematical formulae. No, it cannot be patented. Algorithms. No, cannot be patented. Naturally occurring organisms, they are already there, so you cannot patent them. Laws of nature already there. No, you cannot patent them. Abstract ideas, you cannot patent them. Natural phenomena, cannot patent them, right? So these are non-patentable subject matter. When it comes to the most products, every form of intellectual property rights can be obtained. For most products, as I've told you that there are a number of intellectual property rights like trademark, design, industrial design. For one single product, right, every form of intellectual property can be obtained. For example, I give you an example of camera, right? Camera, I can patent it for every individual improved mechanism. My mechanism is there. For that, there is a patent. For design, for its aesthetic, outer shape and contour, I can go for industrial design, right? Trademark, I give a logo to it, right? For example, I say Kodak, right? That's a trademark. Copyright, for manual booklet, which is denoted, that is also a patent. So you can see for a single item, I am going for all the intellectual property rights, patent, design, trademark, and copyright, right? So why to file a patent? So now we know what is patent, why should we, how it is to be followed, what can be patent, what cannot be patent. Now, if what can be patent, we know that what is the advantage, what benefits do I get when I have to file a patent application? First of all, The object of the patent law is to provide a statutory right to the owner of the patent for a certain period of time to stop others from using, selling, or working out this invention. For example, invention I have done, why the others who are selling my idea should gain without giving me anything. Now that's not done. If it is patent, they have to give it to me. They have to give some royalty to me because it was my idea. Right? So making profits or earning royalty through putting the invention into practice and exploit it commercially. I can exploit my intellectual thing commercially, right? Through patenting. Then to disclose the invention and practice that invention and make it work, thus encourage scientific research and new technology. To stimulate new inventions of commercial utility. To pass invention into public domain after the expiry of the fixed period of monopoly. What does this mean? That if I am granted a patent, I will be granted it for a limited time. For example, they will grant me patent for around 20 years. After 20 years, till 20 years, the person who is using my patent, my technology will keep on giving me royalty. After that 20 years, he or she can use it without giving me royalty. So it's a 20 years locking period, right? So why patent an invention? Because it is the recognition for the inventor, right? It is the incentive to develop a commercial product, license to an existing company, start up a new company, protection against imitators, right? So that is how I can patent my invention. Now, world's first instant noodle. I will just give you some very interesting example, right? For example, world's first instant noodle made inroads into the global market by way of patents. So what happens that Mr. Momofuku of Nissan Food Products had embarked on a quest to create noodle that can be eaten anywhere with just a ball and chopsticks. So his research resulted in a successful development of world first-class instant noodles, chicken ramen, in 1958. And it turned out to be a big hit. But then when it turned out to be a big hit, number of other companies, crude imitations, they also appeared in the market. But then Nissan had already patented it. It used its patent on the manufacturing. And then all the other methods were counterfeited. So that is how that it allowed the chicken ramen to retain its exclusivity. So that's a big, big, big benefit. Then it comes to another company, Gold's Touch. 1 second. Just excuse me 2.
Ma'am, the slide has been stopped.
Ma'am, I'm just sharing it once again. It is not shared now?
Okay, no problem.
It's not shared?
No, the slide is not. No, slide is not visible.
1 second, ma'am. I'll just share it once again.
Yeah.
I have to unshare it and then I have to share it.
Yeah, you can. Yeah.
Now it is shared, ma'am? No. Hello? No?
You have shared, but the PPT is not open. Ma'am, the PPT is not seen.
I do not know. 1 second, ma'am. I have shared, but it's not showing at your end, no?
No. Oh, you have, ma'am, while presenting, you share the entire screen of your laptop and then minimize this particular window and then open your presentation.
Okay, okay. I'm doing the same, but I don't know why it's not coming. Now it is shared?
Yes, 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 it is coming.
Yeah. I'll just go
Okay.
for, yeah. Yeah. So
Yes.
now the next one is a very interesting example that there was a company, Gold Touch. I think nobody has heard about that company. But just because of patent, that company has the guts to fight with Microsoft. I think everybody has heard this. What happened that Gold Touch, which is a very small company, it developed an ergonomic keyboard maneuvered into different positions to suit user needs and mouse design. Very different mouse design it had, right? And it filed application for patent for its product, and it was licensed to Luxembourg and IBM. Subsequently, it approached Microsoft also to discuss the licensing because it's already given to IBM in Lexmark. Right. So what happened that Microsoft did not pay any heed, but year later, because this company had gone to them, they visited and they had showed their design. Suddenly, this Gold Touch started losing sales. They went ahead and say, "What happened?" And then they saw the same type of mouse or the keyboard was available with the logo Microsoft, which was naturally Microsoft is more acceptable than the lesser known Gold Touch. But thankfully, they had done that patenting with for this. So this is because the power of Microsoft logo greatly reduced the potential sales of Gold Touch. But only because of their patent, Gold Touch could even think of stopping the multinational Microsoft from selling the patented product. So that is, you can see that what is the power of a patent, right? So that is about all the patenting. I think that you know what is the importance of the patents, why to file the patent. Now, when to file a patent, when you are ready to file the patent application, immediately after the invention is developed. You have thought something, you have made the prototype of it, file it. Delay in filing may involve certain risk, like other invention of substantially same nature may take the advantage of priority, depriving the true and first inventor. An inadvertent publication or invention by inventor or others may damage the novelty of invention. Patent should be filed before any kind of publication or commercial using or communication to others. It should be filed immediately. Where to file a patent application? The appropriate, it's not that you can, because it is a territorial right. So the appropriate office of the patent office shall be the head office of the patent office or the branch office, as the case may be, within whose territorial limits. For example, you are the residents of that territory, your place of business, or where the invention has actually originated. For example, if you do not have any business or domicile in India, then address for Indian service has to be in that territorial limit, right? Document can be filed in the patent office through online e-filing and through post, or can be submitted in person. For example, you are in Chennai, then your territorial jurisdiction are in the states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and Union Territories of Pondicherry and Lakshadweep. For Mumbai, these are some of the states where they have to file their patent in Mumbai, Patent Office Branch Mumbai. For Delhi, all the North India files the patent in Delhi. Then rest of India files in Kolkata. Right? So this is the jurisdiction where you have to go. How to file? What are the stages? The stages are: first, filing of a patent application, publication after 18 months, pre-grant opposition, request for examination, publication of grant of patent, post-grant opposition to grant of patent, and decision by the controller. So I'll discuss this one by one. How to file a patent application? with one of the patent offices based on territorial jurisdiction of the place of office or residence of the applicant, you pay the required fee. Then these are the information concerning the application form, and details of the fee are available at www.ipindia.nic.in, and even the guidelines are also available over there. You can file two types of applications: provisional and complete. Complete means provisional means you just have an idea, you know it will work, you have some preliminary study, patent it. Then you are given 12 months from the date of filing of provision to complete that, because we do not want any delay, because by the time you're thinking all the products are ready, somebody else has done the work. So the moment idea comes, just a small prototype, you know it is going to work, file it. That is provisional, just a few pages. Then details can be filed after 12 months, right? So that is how you file. Then in provisional specification, just a little description regarding the invention. Whereas in complete, you have the description, total description, as well as the claims. Description means what is the best mode, what is the background, how you are starting your patent, why it is noble, and claims, what are you patenting. Means that this is claim, means that what all you are claiming, so that else others cannot use that without your jurisdiction, without asking you, right? So these are claims are the key to all the patents. They protect the legal rights of the patentee. It defines the legal boundaries of the granted exclusive rights. For example, what the inventor is entitled to, right? And what the inventor will be exploiting commercially, and it will exclude others for practicing or making the same product as the inventor is patenting, right? So that is how. What are the parts of the patent? When you have to file a patent, it is just like a manuscript. When you write a manuscript, what do you have? You have abstract, you have introduction. So here you have abstract, you have background of the invention, then summary, that what are you patenting? And then figures with brief descriptions, then detailed description, right? How it is made, how it can be used, and then claims, independent and dependent claims. What are the legal boundaries? That nobody can go and make this part, nobody can make this part because this is patented, right? So that are the parts of the patent, right? But once you write the document, an examiner will check the formal requirements before accepting the application and the fee. This is done immediately, right? Then issue of application number and the cash receipt, this is done the same day. And in case of receipt of application by post, cash receipts, application number is sent by post within 2 to 3 days, right? Now, the application is kept secret for about 18 months. For example, I file a patent, right? It will be kept secret for 18 months. In the 19th month, it will be published in the public domain, right? So whosoever looks at this, for example, I have patented a bottle, design of the bottle, but somebody else says, okay, I have also done this. So he can raise the opposition. So that is why it is published for the public domain, right? So importance of publication, the applicant shall have the like and privileges and rights if a patent for the invention has been granted on the date of publication of the application. The applicant shall not be entitled to institute any proceedings for infringement until the patent has been granted. Right of the patentee in the case of applicant means that when it is published, it is already, and in the subsequent time when it will be granted, this date will be important. This date will be very, very important, right? So request for examination, application is examined on request. Request for examination can be made either by the applicant or by the third party. A period of 48 months from the date of filing is available for making request for examination, right? So that is, 1 second, it's, I think my slides are again gone. My slides are visible. Now, visible?
Yes, ma'am. Yes, ma'am.
Yeah. Then examination application is sent to an examiner within 1 month from the date of request for examination. Examiner undertakes examination with respect to whether the claimed invention is not prohibited for grant of patent, whether the invention meets the criteria of patentability. Then after this, it is examined, it is published. Then first examination report, FER. After proper examination of the patent application on the criteria of novelty, the examiner can ask number of questions. He may say, no, it is not novel. It was published. Similar type of report is also already there in the literature. So he can ask a number of questions which the patentee has to reply. Patentee is given a proper timing to reply to all these queries raised in the first examination report. So it is around 1 to 3 months are given to the examiner to submit the report to the controller. So then once we submit the report, right, then it is vetted by the controller. Now, amendment of objections by the applicant. For example, the FER will give an opportunity to the applicant to file a response and overcome the objections raised by the examiner, right? Within 12 months from the date which the first examination report has been issued to the applicant, the application should be placed in order of acceptance. In case of unjustified response, for example, I tried my best to give all the answers to the FER, but if the controller is not convinced, he or she has the power to refuse the grant of patent or ask for amended claims. So that is the process. Then response from the applicant, 12 months time from the date of issue of FER. If objections are met, grant of patent is approved by the controller within a period of 1 month. Pre-grant opposition, after publication, an opposition can be filed within a period of 6 months. Opportunity of hearing the opponent is also available. Then what are the grounds of opposition? For example, I say, okay, somebody is trying to patent this, but it is not, it is wrongful. It is publication, it is already prior published, right? Prior public knowledge is also there. Obviousness, it is not a invention. People can raise any type of objection which has to be taken duly by the controller. So that is the opposition of the grant of patent. Now it is opposition are sent to the applicant. A period of 3 months is allowed for the receipt of the response, and then consideration of pre-grant opposition. After examining the opposition and the submissions made during the hearing, controller may either reject the opposition or accept the opposition. So this is again done within the period of 1 month from the date of completion of the opposition proceedings. And then if it is not opposed to pre-grant representation, opposed but decided in favor of applicant, if it is not refused or it is granted with the serial number and simultaneous notification in official journal. So this is how the patents are granted. This is one of the patent I'm showing. This is my patent, and this certificate is given to the patentee, and that is how the grant of patent helps. So these are the stages. I'll just summarize: filing of the patent, publication, request for examination, examination issue of FER, grant of patent. If it is opposed, the decision of the controller, appeal, and then it is granted. Right? So these are the Indian patent application fees. These were very, very high, but fortunately in 2021, 80% decrease in fees has been announced by the government so that more innovations are patented. So now the fees are very, very nominal. Right? Who can apply for a patent? A true and the first inventor who holds the rightful ownership in the invention, a person who is an assignee, legal representative of the first and true inventor, a legal hire of the first and true inventor in case of demise of the true and the first inventor. What are the documents which are required? You should have, first is the covering letter, then a patent, you have to write in the form, this is the form 1 where you have to, this is a simple form which you have to fill to file a patent. Then form 2 in the duplicate, this is the second, all the forms are very simple. This is the second one, and then the third one where the just an undertaking is there, and then power of attorney if it is filed through an attorney, then in declaration what is the inventorship, and this is how you file the patent. Very, very simple process, right? So these are the renewal fees. For example, to keep a patent in the force, the renewal fees shall be payable at the expiration of the second year from the date of patent or of any succeeding year, and the same shall be remitted to the patent office before the expiration of the second or the succeeding year. While paying the renewal fee, the number and the date of the patent concerned and the year in respect of which the fee is paid shall be quoted. So these are the renewal fees. And this was all I was discussing about the Indian patent. But you can also go file an international application, right? So it can be directly filed through International Bureau Geneva online. And it is just a PCT, Patent Cooperation Treaty. It is an international treaty which provides facility to an applicant of the member country to file a single patent application and designate the countries in which the applicant wants to protect the invention. This is known as international phase of patent application filed under PCT. So again, everything is same. Most the documents which are required just the same as IPR, and the fees are different. So before filing a patent, understand your invention, research your invention, choose the type of protection you want, trademark, trade design, industry design, or a patent, draft your patent application, and wait for a formal response. I wish good luck for all your decisions, and I hope a number of patents coming through our young generation, because you all are very, very innovative thinkers, and wish you all the best. So that's all from my side. Thank you.
Yeah.
Thank you, ma'am. It was really, really very much informative. And one question has been asked by one student, like if suppose they have an idea, but they don't know how to, means they have the process design and all right, but they want to know that how they can get the fund.
See, patenting is not funding. You have to get the fund. The only thing is that you can patent, you can go for filing of a provisional patent. And then if you have filed that provisional patent, you can go to a funding agency, because that you have an idea which is patentable, right?
Okay.
Because
yes.
Patentable. Then the funding, that will add weightage for your funding opportunities.
Okay. Means
Right.
we have to approach the funding agencies.
Yeah.
Okay.
But if you say that this is the idea which is patentable, which is already provisional patent has been filed, so naturally funding agency would be very much like it's likely to fund that, because it's already patented.
Okay.
Right? The idea is already patented. It has been proved that it's an innovative idea. So that will add to that.
Okay. Another student has asked, like, if they want to search that whether their process or whether their idea has been already patented or not, then how can they themselves find that data?
There are a number of search engines on the net where you can find out that whether your idea is patentable or not. Right? So because you should prior art, you have to go for the prior art, that what is already available in the net, what is already publishable, and how then you have to prove, you have to give the justification that your idea, how your idea is different than the previously published one.
Like, is there any website or link with which the student themselves can find out these data?
Yes, Dr. Prabha, I will forward the links to you so that you can share with the students.
Yeah, okay, ma'am. Sure, I'll be sharing with those. And one more thing, one student had asked, like, suppose they are doing this project and all, and they are patenting files through the university.
Yeah.
Then what is the procedure to?
University, if you are filing through the university, then university becomes the patenting organ or patentee, right? And you become
Okay.
the inventor. Both
Okay.
are acceptable, right? Because even if the patent is filed through the university, you are the inventor. Inventor is not changed,
Okay.
right? But the filing organization is changed.
Okay. And suppose if the academic and the industry people both are, doing
Involved.
a work on one particular project, then what will be the,
You can have inventor and co-inventor. So in that
okay.
case, the company becomes the co-inventor and you become the inventor, or the vice versa. That is because
Okay.
in the
And
same
the,
patent you can have around 10 patentees. You can have 10 inventors.
okay. Okay. And what we can say, the funding will be from both sides?
The funding depend. I'm telling you that funding has nothing to do with the patent.
Okay. Okay.
You know, patent is a different. The patent is that how you have done that research. That's on to you. Patent is
Okay.
just giving you the copyright of that. That's it.
Okay, because one student has written that they are working with industry and academics both are working on one project.
Yeah.
So who will contribute for the that thing? So
That depends
that's
upon, that is like company and the university can, because if the patent is filed and it starts on it is commercialized, then both will earn.
okay.
So they can, both of them can put money for that idea,
Okay, okay,
right?
okay, okay. So this was. Uh, Hello, am I audible, madam?
Yes, you are audible.
Hello. Okay. So, okay, ma'am. These many questions were there from student side. So now, on behalf of our chemical engineering department and Parul University, I would like to thank Dr. Sunita Ratan to present this webinar on such a wonderful topic, and it was really very informative session for all the students. So, thank you, ma'am.
Thank you so much, and thank you for inviting me. I look forward for other research topics also. Right?
Yeah, sure,
Excited,
ma'am.
and I'll
Yeah,
be
thank you.
more than happy.
Yeah.
Thank you. Thank you so much. Thank you.